Welcome back to Canadian Justice, where we're discussing a recent federal court decision that found that a federal plastics ban is unconstitutional. Now, Brett, in the last segment, we talked about some of the concerns that organizations like Kaitlyn have about single-use plastics. We know that the federal government has their concerns, but anything they do to address those concerns, must be within the division of powers architecture of our Constitution. And we know that there are provincial and even municipal restrictions on the use of single-use plastics. Now, this varies across the country, but we know that some levels of government are already regulating in this area. So why would the federal government be stepping in here, especially if there's a question about if they have the authority to do that even?
Yeah, so it's a good question. And to some extent, we're seeing the same dynamic play out on many different environmental issues across the country. As we can appreciate, the framers of the Constitution didn't exactly envision environmental regulation when they drafted it. And so every few years now, we're seeing a new issue come up where both the provinces and the feds want to regulate. And in this case, it's not about um, plastics per se. I think everyone has an interest in regulating those. It's about who can do what. And the court really picked up on it in this case. And I just want to read a quick quote where they say the ubiquity of plastic in society means that most businesses and organizations will use PMIs and will be under provincial jurisdiction. So that very much reflects the fact that provinces do have a role in this and are playing a big role. And the court has to be extra careful with what they're going to allow Parliament to do under the criminal law power.
Yeah, so I want to talk about that criminal law power. Kaitlyn, the consortium of plastic companies that argued that this ban was unconstitutional, they said that the cabinet order was being made under the argument that it was a criminal law regulation. And they said that a plastic ban doesn't fall under criminal law. Now, certainly the federal government can use criminal law powers to enact environmental protection legislation. And we might think of other cases that involve toxic chemicals like mercury and lead and asbestos. And this was all considered by the federal court. But how dangerous or how toxic does a chemical need to be to meet the test to bring it in with the scope of the criminal law? I think a lot of us might automatically see mercury as quite a different type of product than, or asbestos is a very different product from, a plastic shopping bag. How does plastic, in your view, meet that test?
Well, it's an interesting question. And certainly in the Hydro-Quebec decision, the Supreme Court did give us some useful guidance. So there they found that CEPA, the Canadian Environmental Protection Act, protects not only against substances that are toxic per se, so things like asbestos that you mentioned, but that it's also intended to protect against harms caused by substances that may, when released into the environment in a certain quantity, concentration, or condition, become toxic. And when it comes to plastics, we absolutely know that that is happening. They are being released in quantities that are causing devastating impacts right now.
Brett, what's your take on the criminal law power and how plastics do or don't fall within the scope of criminal law power?
Well, I think Caitlin summarized it perfectly there. In the criminal law jurisprudence, there is really this effort by the court to only use that power when the prohibition in question has a criminal character, right? And so you see the courts in the environmental context. That's why they're fixating on the toxicity and the significant harm aspect of it. They're trying to find something or constrain Parliament to something that truly is severe and truly has potential to have significant consequences. It is definitely an unsettled area right now, and we see that back and forth in a few cases. Um, but certainly when it comes to SEPA, we're seeing that sort of toxicity threshold. Um, in this case, the problem was just that the order itself included substances that did not have the scientific justification in the RIAS and the scientific assessments, and it appeared to be a bit too broad for the court's liking.
Now, is part of the issue, Brett, just about 30 seconds, that the term plastics is just, it includes so many different things, includes like put hundreds or thousands of different items.
Yeah, it's arguably not a single substance or a class of substances, which is part of the machinery of SEPA.
Right.
That's the language it uses in the
Right. The
statute.
way
And
mercury or asbestos would be a single substance. I mean, these different plastic
that's
items
correct.
are really across a huge spectrum. We've got to go to commercial break now, but we'll be right back.